Well, welcome Adam Tutaj to the Wellness Law podcast. Everyone, I would like you to meet Adam. I've known Adam. He's an attorney, and I've met him through the Wisconsin State Bar Health Law section. I believe you were the chair at the time that I started participating in the health law section for the Wisconsin State Bar. And that's how I got to know you. And you have been such a leader in the business, tax, and health law space in Wisconsin that I wanted to have you on the podcast because I wanted people to learn from you on that expertise. Right now, you are a shareholder at Meisner, Tierney, Fisher, and Nichols, and you have authored many articles on business legal entity. In fact, our state has some changes. Wisconsin has some changes in its legal entity statutes. So welcome, Adam, to the Wellness Law podcast.
Oh, thank you, Barbara. And I'm trying not to think back to how long it was ago that we were both on the board together. It's been a while.
And over a decade.
Yeah. No,
Yeah.
Appreciate you having me here. I'm delighted to talk with folks. As you mentioned, I've been working in business tax and with a lot of healthcare providers as a kind of substantial part of my practice. I'm primarily on the provider side of things. So, working with both doctors, dentists, and certainly more recently, a variety of other practitioners in, what's now being called the wellness space. And interesting how these opportunities come to us. When I graduated law school, going back, several years now, it just so happened that I was clerking at the firm at the same time that the infamous Stark II regulations came out. So I became the one tasked with reading and learning those. And shortly thereafter, HIPAA came out. So I became the one who learned and read those. And so added this sort of hard health law piece to my practice, which was before that, kind of more of a straight, corporate tax and, just setting up business and, retirement plans and tax planning for doctors. But then this healthcare, regulation became an adjunct, and then this, just sort of took off from there.
Yeah, you mentioned two health laws, Stark and HIPAA, that are the bane of many health providers' existence. But luckily for most wellness providers, they don't apply. And that's one of the advantages of being in the wellness space as opposed to the health care space. Sure. So I have a lot of clients who come from the Center for Health and Wellness Law who are in the wellness space as a health coach, wellness coach. They call themselves all kinds of different names, consultants who advise on nutrition, exercise, de-stressing, work-life balance, all kinds of different lifestyle things that people can change to improve their health and well-being. And I also have licensed providers who are escaping the regulated healthcare industry and trying to find a path that makes sense for them. And they adopt practices that are giving functional medicine services, integrative medicine, holistic health, naturopathic, Ayurvedic, Reiki, all kinds of different disciplines that are on, I call the fringes of the traditional healthcare complex. And so they're looking for starting their own practice and hanging out a shingle and advertising themselves as available to give people these kinds of services, usually across the country, not limited to just where they are, but because of all the virtual platforms that exist now, they feel like they can offer their services to a wider audience through virtual platforms. So I was hoping you could enlighten us and those types of clients with the types of considerations they need to have when they're deciding they want to start their own business. What are some of the first things they should be considering as they embark on that journey?
Sure. One of the first things I tell practitioners of any sort when they're looking to strike out on their own, start their own business is, first and foremost, take a look back at where you're coming from. And by that, I mean, in particular, look at your employment agreements and do you have any restrictive covenants, right? So it's not uncommon that you see a retiring physician or a retiring nurse practitioner or somebody that, because of where they're coming from, sometimes a large health system or the like, they may have a restrictive covenant that could have some nasty surprises for them, both in terms of, and those come in a couple different flavors. There's what are called true non-competes, which say in a given geographic area, you just cannot do X, and it's usually specialty specific. So for example, if you were a internal medicine specialist, you might be limited to that. So if you're truly going off into something that is now not internal medicine, you may be okay. And that may not be so bad. But then the second type of restriction is what we call a non-solicitation. And that's usually a more customer focused. So if your plan was, for example, that you were gonna, pick up the phone to all your clients that you're working with before, and you liked treating and knew and loved you, and even if you thought you can offer them great services, if those services compete with what your former employer was doing, you may be getting a nasty gram in the mail from someone like me saying, hey, cease and desist contacting these clients. So first up is make sure that you're in a position to actually operate in the area you want to operate in. Do you need that former client base, or are you really starting from scratch? And what is your ability to kind of work with that former client base? So that's first way to kind of get that pinned away. As you're making that progress, so a lot of times while you're in that, kind of wrapping up that employment, you may still be employed and you're sort of looking around corners, getting ready to start your practice. So there is a whole concept of, just while you're employed, you have a broader duty than just even if you don't have a non-compete, while you're employed, you still have ongoing duties. So there's this concept of calling preparing to compete. So not that necessarily wellness practitioners regard themselves as competing or even doing something that is the same, but the employer might. So while you're employed, you just have to be careful that all the prep work you're doing has to be off company time, using your own materials, using your own facilities, your own computers, things like that. You can't use the employer's resources to start up your own business. Don't be taking forms, don't be taking manuals, things like that. That belongs to the employer. You got to be ready to kind of start from scratch. So I've seen folks who've put a foot wrong that way because they, grabbed a bunch of forms or handbooks or things like that. You got to be very careful with that. But on your own time and on your own dime, you can, even while employed, start to look around and get ready to set up a new practice. That includes things like searching out new office space. You can lease premises. You can form your entity even. You can get ready to start practicing. The only thing you can't do while you're still employed is advertise and hold yourself out and actually start providing services. But there's a fair bit of work you can do in that sort of preparing to compete stage that is acceptable. And then one of the first questions I get from a lot of startup folks is, so I hear I need an entity. Should I have an entity? Mm-hmm. Yes. There's a number to choose from. And the biggest considerations I always start with are, first and foremost, how many people to start? Is it just you as the sole owner, or are you going to have a partner? If there's going to be somebody else in the mix, that opens up a broader range of entities. So whenever we talk about partnership entities, that includes general partnerships, which no one forms on purpose, LLPs or limited liability partnerships, or limited partnerships, things like that. The key feature of a partnership is you have to have at least two people or you don't have a partnership. So if it's just you, really the only entity forms that are available are the corporation or some species of a corporation, or the LLC, the limited liability company, where you can have a single member. Mm-hmm. Now, what's the benefit of having that extra business? Generally speaking, it is because of some form of limited liability, meaning that what's at risk when dealing with the public and vendors and everything else is the money you put into the company. So they can sue the company for everything it is worth. That doesn't automatically mean they can sue you for everything you are worth. There's some exceptions that could cause that to fall down, but generally that holds. Where it gets tricky for the wellness space and healthcare area is that certain licensed professions, in particular physicians, but also dentists and others, by law, you cannot limit your liability for professional malpractice. There's just this, when we've created in Wisconsin and a number of other states, this idea of a professional corporation. These started cropping up around the late 60s, early 70s, when a number of business and tax professionals wanted their physician clients and dentist clients to be able to avail themselves of the tax and employee benefit provisions that were available to all other businesses in this world. And they weren't because of certain licensing requirements and the like. And so states started creating these entities called, in many states, they're called professional corporations or PCs. And I like that term a lot better. Here in Wisconsin, we call them service corporations or SCs.
Yes.
I don't like that because it gets confusing, because whenever somebody says they're an SC, sometimes they think that means they're also a quote S corp, which is a tax election. It gets very confusing sometimes for physicians who you can be an SC service corp, but still be a quote S corp or a C corp for tax purposes. It gets very confusing. I wish we were PCs, but we are where we are.
Great.
But one of the big features of these are the professional always maintains full personal liability for their professional malpractice and of those they supervise. So, and that's a feature of ethics, professionalism, and probably the plaintiff's bar, looking at, when these laws were being enacted, they wanted to make sure that, there's still some professional responsibility in there. So even if you form that entity, it's going to have limited utility in the sense that it might give you limited liability for, say, a vendor dispute. If you don't pay for something like on a copier, or if there's a slip and fall outside your building, like a true premises liability, something that's not professional, you might have general protection for that. But I tell all my new startup clients, what I'm creating for you is paper protection. It's a paper shield. It generally works. It's useful, it's helpful, but it doesn't bring money to the table. Your best friend in this world is insurance. You really need to go out and make sure you've got insurance, because then if and when the claim comes, they will sue everybody anyway. Even if you form an entity, they're going to sue the entity, they're going to sue you personally, they're going to sue everything. So having that insurance is actually far more important than actually having the limited liability entity in place. It's good to have it, don't get me wrong, but the insurance is critical.
Yeah. Well, I want to go back to what you've been saying and kind of parse through it. So for a lot of wellness providers, they're not licensed professionals, or even if they have a license, what they want to do is operate outside of that license.
Right.
So for the purposes of that professional corporation, that wouldn't apply to them because
wouldn't be available. Right. So under the statute, there's really only 15 licensed professions that are recognized. And they're all ones that have, and they make specific reference to whatever examining board gives that license. And there's really only 15 of them outside of that, in what we call the healthcare space, or what we call healthcare professionals. And we have a weird quirk in our law, unlike some others, where professional corporations generally, they must be owned completely and managed by people that hold the same license. So for example, only lawyers can be owners of a service corporation that is a law firm. Same is true of accountants. But there's an exception that treats all healthcare professionals, capital H, capital P, as being one and the same almost, at least for corporate law purposes. So if you're anyone in that 15 group, you can be co-owners of the same practice. A massage therapist or bodywork therapist can be a co-owner with a neurosurgeon in the same practice. There may be some other ethical rules that will certainly dictate how their operations have to navigate, but from a pure corporate law standpoint, they can be co-owners.
Yes, but for the unlicensed individuals who are providing various wellness services like health coaching, and they're all usually the people that I encounter in that area are on their own. They don't have partners.
Sure.
They're just doing it out on their own. The LLC is probably a good legal entity option for them to consider.
Yes, and biggest reason is because of the flexibility. So when you're choosing that entity, and again, when you're a solo person, your only two entities really are the corporation and the LLC. The biggest driver is going to be, usually from a choice of entity standpoint, is going to be what kind of tax treatment do you want? And there's really two flavors. There's what we call pass-through treatment, meaning the entity doesn't pay taxes, it just reports the income. And then you get what's called a K-1, and then you report it directly on your personal tax return. And then there's actual corporate treatment, which is called, they say, be a C corporation. That's where the entity itself pays taxes. And generally, for a lot of small businesses, pass-through treatment is desirable. It is uniquely in the healthcare space or any space where you're not likely to have a lot of appreciable assets, that a C Corp might be just fine. But generally, the pass-through treatment is just easier all around.
Yeah.
And then when you talk about what kind of pass-through entity, LLCs are wonderfully flexible for a couple of reasons. So if I wanted to form an S Corp and a subchapter S corporation, not an SE, but a subchapter S Corp, I form my corp, but then I have to make all these extra elections. I have to timely make elections. I'm going to have to file this extra tax return for the for my corporation. That's an extra cost. I have to file that extra tax return. Then it comes to my return, and then I file there. If I'm a single member LLC, the neat thing is you're not a partnership because you don't have two people. I could elect to be a corporation. I could elect to be a C Corp or an S Corp, but many startups, what they'll do is they will just treat themselves what's called a disregarded entity. You don't exist for tax purposes. You are an LLC for business and corporate law purposes, but all that happens is you just report that LLC directly on your 1040 on a Schedule C. So there's no extra entity return. Everything just flows through directly onto your return, and that makes it a little more efficient that way.
Yeah.
Now, of the two tax treatments there, the pass-through treatments, the one driver why a lot of folks do think about that S corporation status has to do nowadays primarily with self-employment tax. The big difference, I guess I'll break down this way, is with an LLC, if you work there and it's your business for a service business like a wellness practice, every dollar that comes through to you is subject to self-employment tax. So essentially, you're going to pay the full employer portion, full employee portion, and the Medicare, the extra 3.9%, all the way up to their limits. You're going to pay it. Every dollar is subject to it.
Mm-hmm.
In the subchapter S world, you're only subject to self-employment tax or you're actually subject to, you pay employment tax, not self-employment tax, on your reasonable compensation. So there's some, I guess we'll call opportunities for planning, where if there is revenue you have that is not from your own services, right? So let's say you had some employees, not co-owners, but employees that also generate fees. You'd be in a position that you may have income lying around that is not from your own services, in which would be appropriate to say, I'm going to take this as a distribution, a dividend, and not pay extra self-employment tax on that. Because it's not from my own services, it's from other services. It's from my ownership. So there's a savings that can be had there in the S Corp field that's not available in the LLC. Everything that comes through in the LLC is employment taxes, and accountants will generally be able to help you figure out, kind of plan what that level of savings would be, and will the savings that you could generate offset the extra administrative costs of having an extra return and an extra entity and all that other stuff.
And that's really the key piece that I think a lot of my clients, when they're coming to me and to the firm about their wellness business, they have questions about, well, should I do it? I was told I should do an S Corp. I'm not even sure what that is. And would you say, Adam, that that's a question that you would be best suited to advise on? Or you mentioned that, they would work with an accountant, or both?
It's usually a combination. It's generally the accountants will know a little better the nitty gritty of what they're going to be earning and can do those calcs. And frankly, the accountants generally charge less per hour. So that might be a more efficient process there. But in terms of high level, what are the kind of the judgment points? That's certainly something that I will work with clients at the very front end when we're deciding, well, what kind of entity do you want to be? That'll be a factor that we'll walk folks through. And the other benefit of the LLC is you can form that entity, you can change your status going forward. So if I'm an LLC, especially when I know I'm not going to be making as much money, you may be fine with the straight pass through because you're a solo, there's no other employees, and you're not making enough money where the self-employment taxes are going to wag the dog, and you're comfortable just having a real simple LLC. The minute you start taking on other fee earners and it grows, you could then elect going forward to say, okay, now I want my LLC to be taxed like an S Corp. And you'd file what's called a check the box election. that means I want my LLC to be taxed like a corp. Then I file an extra election to be treated as a S corp, and I've done this many times for clients where we change that status. So after those first couple of years where they were in startup mode, now they're going to be an S corp going forward, and now they're going to have to, now they're going to have a salary policy, and they're going to decide how much they're going to pay themselves, and then that's all they have to pay self-employment tax on, and then all other earnings they'll treat as S corp distributions.
Well, that's really helpful. So I think, yeah, that the people listening to this podcast should understand that you don't have to have all of these decisions made at the outset. You can decide, I'm going to form an LLC because I like the idea of protecting my personal assets and keeping my business separate from my personal. So I can do that, and I can have somebody like Adam help me with that. And then later, maybe a few years into your wellness practice, you can reconsider, doing the S corp status, and because it makes more sense, or you have more bandwidth to think about that at that time. And so you don't have to have everything planned out. There are certain steps that you should take initially, and then as you move forward, you can consider those other advantages, like the S corp election for the LLC. That's what I'm hearing you.
Yep. And there's and the LLC is just neat because I can do all those changes of that flexible tax status without having to change what kind of entity I am. There are other options available too, that if you, and I'll give you an example, if an entity did form as an LLC to start with, and then later determines, or maybe has determined for them, you are a licensed profession and we don't want you practicing in the LLC form, you can actually, under our statutes, what we do, it's called cross-species mergers and conversions. You can convert what is an LLC into a different form of entity by filing articles of conversion. So I've done this with practices where I've found that they were structured as LLCs. Someone got some advice that they should be an LLC. Then we figure out, gee, you really should be a service corporation for a number of reasons. And so you can convert that LLC into a service corporation by filing these articles of conversion. And now you are a service corp. Or you're now a service corp. The other piece to that is that you want to make sure you do this in a way that does not change what's called your EIN, your employee identification number. If you work with Medicare, Medicaid, I know a lot of folks don't in the wellness space, but if you work with insurance, and I know a lot of folks don't in the wellness space, having to change your EIN can be a disaster. So there are ways, though, you can convert your entity in a way that also preserves your existing EIN with the service. And that's just a set of forms to navigate to do that. But for the startup practice, the LLC is just so flexible because you don't have to worry about these conversions. You can just make the S election, and if you know that licensure is not an issue, that LLC can stand you in good stead.
Yeah. For those individuals who do have healthcare licenses, you mentioned not being able to convert and not preserve the EIN. What about the NPI number, the National Provider Identifier number? I assume that it doesn't get affected if with a conversion, does it?
Not the one for the physicians. As for the entity itself, I've understood, and this I'll have to check on, but that usually for the entity is tied to the EIN. So if the EIN stays, usually the NPI stays. But okay. I have not done as much in the billing area to be sure of that last point.
Yeah. Well, for those wellness providers who are out there listening, you aren't licensed, not billing Medicare, you're not billing insurance, which is the bulk of wellness providers. You don't have to worry about NPI number. That is specific to licensed providers who are billing Medicare, Medicaid. They need that NPI number before they can do that. So no worries if you are not one of those individuals. Okay, so this has been really helpful, and I knew it would be. And I just want to make sure people who have maybe follow-up questions or want to connect with you, Adam, how can they find you? What is your contact information?
Oh, sure. So I'm at the firm of Meissner, Tierney, Fisher, and Nichols. Our website, that's at www. M as in Mike, T as in Tom, F as in Frank, N as in Nancy.com. And we have my contact information is all there. And we're a general practice shop in the sense we have both corporate, we do litigation, we work very close with a number of small and closely held businesses. And on my end, in addition to the corporate and tax side, I've often wound up interfacing with regulators at DSPS for those times when, to the extent that you are dealing with a licensed profession again, and we see this in the wellness space where physicians, for example, enter into supervisory agreements of all stripes with wellness professionals that may or may not be licensed. And I'm always cautioning my physicians, particularly those that are nearing retirement. They may have already retired, but they want to be active. If you're going to supervise, if you're going to be involved, you're going to be a medical director that wants to affiliate with these, more innovative healthcare spaces, just be involved and be active. If you're signing on to supervise, pay attention, be involved, and be mindful of whether or not that particular space does require some licensure. I've certainly seen the experience of folks who come from other states with specialties that are licensed in the other states, but they're not licensed here in Wisconsin. And so they pick up where they left off in the other state. They think, in some other state that, such a license exists and they've had affiliations with doctors, then they come to Wisconsin, they hook up with a Wisconsin doctor and they motor ahead as though, well, yeah, I had the license over in Arizona and or in California or in Texas, and now I'm here. Why can't I do the same? Well, because we have different laws.
Yes. Well, yes. And that physician supervision is critical because that's on the physician. That's their responsibility to ensure that they are supervising at the appropriate level, whether it's in person, in the room, in the building, or remote, if it's possible, depending on who's being delegated the service. So very, very important for that physician to be aware of their responsibility because their license is on the line, as you mentioned. So excellent. Well, thank you so much, Adam. I will make sure to put your contact information in the description of this podcast. And I really appreciate you sharing your expertise with the Wellness Law podcast audience.
My pleasure. Good talking to you again.